reason to deprive the statement of First Amendment protection. Well then, second, what about the fact that these statements were not only false, to some extent, but they were defamatory, defaming individuals who had been accused in the ad. And the court says the fact that a statement is defamatory does not rob it, deprive it of First Amendment protection. We're talking here about criticism of public officials, the heart of the First Amendment. And the court emphasizes that in our system, there's no such thing as seditious libel, libel on government. Remember the Sedition Act. That was a seditious libel law. But as our system has evolved, the very thought that government could be libeled by what the people say in criticizing government and its officials is inconsistent with our First Amendment tradition. And the court, this is all Justice Brennan, in this masterful opinion, pulling together the strands of our history and pointing out that our system of freedom of speech and of the press is built on the Madisonian premise, the premise elaborated by James Madison, the principal author of the First Amendment. And the Madisonian premise is that in this country, we the people are in charge here, not the government. We the people are in charge. And when the Sedition Act was passed, Madison went back to Virginia and got the Virginia legislature to pass some resolutions opposing the Sedition Act. And those resolutions are a wonderful statement of First Amendment principles written by Madison on behalf of what he viewed as the sovereigns, the true sovereigns in our country, that is the people, and their right of freely examining public characters and measures, which is the only effective guardian of every other right. And Justice Brennan then tracked through history into the 20th century and quoted extensively from Justice Brandeis's great opinion in Whitney versus California in 1927, in which he elaborated on the underpinnings of our First Amendment freedoms and said that it is basically the duty of every citizen to criticize government. We are a country of citizen critics of government. That's how we're supposed to operate. And so Justice Brennan concludes for the court that neither falsity nor defamatory meaning, criticism of a government official, deprives a statement of First Amendment protection. Well then, what about a combination of the two, both falsity and defamatory meaning? And he says that doesn't do it either. That's the lesson that we've learned from the experience with the Sedition Act of 1798. That, after all, prohibited false and defamatory statements about government officials. And Justice Brennan pointed out that the Alabama common law, as applied in this case, was very much like the Sedition Act and applied in much the same way. And the effect in both cases was to stifle criticism of public officials, violating what Justice Brennan said is the central meaning of the First Amendment, the right that we all have to criticize government and government officials. Justice Brennan said that the attack on the Sedition Act, the fact that the editors were pardoned by President Jefferson immediately upon taking office, that Congress voted compensation for the editors and their families, for the recognition within a decade or two after the Sedition Act had expired by politicians of every stripe that the Sedition Act was inconsistent with our First Amendment values. The court said that the attack against the Sedition Act has carried the day in the court of history. And so, in effect, 167 years after the act had expired, the court declared it unconstitutional. It was not an issue in the Sullivan case, but the court couldn't have made it clearer that the Sedition Act was inconsistent with the First Amendment. And then the third point that the Justice Brennan's opinion found, well, that the court found problematical with regard to the way Alabama applied its law of libel was the historical context and what was going on here. Hey, you guys, you pay attention or leave, okay? It's really distracting. The historical context in which the case arose. Brennan said nothing about it. Only Justice Hugo Black, in his concurring opinion, brought it up. And basically what was going on was the segregationist South was attempting to get rid of the northern media covering the civil rights movement so that they couldn't report to the rest of the nation what was going on there, and so that they could maintain the segregationist way of life. And they were using the libel law as a political tool to intimidate the press and get them out of town, drive out reporting on the civil rights movement. And that clearly animated the justices on the court, although Brennan himself never mentioned it. Alina? What Black said? Yeah, well, you can read it. I mean, the point that he's making is that Alabama was attempting to chase the northern media away from reporting on the civil rights movement and using the law of libel as a tool, as a political tool, to achieve that purpose. And that's not strictly a legal notion at all. There was no evidence to that effect, but everybody knew that was what was going on. And that had to be an animating factor for the justices in finding that the common law as applied here was a tool of evil. Yeah. Sorry? Historical context, yeah, in which the case arose. I mean, ordinarily, the court would not have been terribly alarmed by a libel judgment in some state. But here, this was big news. And the segregation South were calling the northern media carpetbaggers who come outside agitators who come down to upset our way of life and so on. That's clearly what they were doing, but not something that fits nicely into a legal analysis of the case. So what Justice Brennan then did was conclude that it's necessary to find First Amendment limits on liability for defamation. Had to be First Amendment limits, had to be constitutional limits, because libel was strictly a creature of state law. So then specifically, what Justice Brennan found wrong with the Alabama common law as applied was first, this invention by the Alabama Supreme Court that criticism of a government agency, impersonal criticism of a government agency, can be taken as of and concerning the official in charge. The court said that's basically like saying libel on government is permitted, and seditious libel is inconsistent with the First Amendment. Secondly, the court found problematical the fact that falsity was presumed, casting the burden of proving the truth on the defendant, and as the court said, imposing a test of truth on whether speech is protected is wrong, at least in the case of political speech, speech critical of government officials. And third, the court found fault with the Alabama common law in that it did not include any requirement of fault, no blameworthy state of mind in any way. And since error was inevitable in the rough and tumble of political debate, imposing a test of truth with no fault, in other words, strict liability, as it's called in the law, that's a term, strict liability, means liability without fault, the court says is totally inappropriate when you're dealing with criticism of public officials. So then the holding of the court, what the court actually decided, given the analysis that Justice Brennan has just been through, pulling together the strands of history, philosophy about freedom of speech and the press and so on, you would think that when the other shoe drops, he's about to say, and therefore there's no such thing as libel suits by public officials with regard to criticism of how they carry out their duties. That's all protected by the First Amendment. And that isn't where Justice Brennan goes. He goes right up to that point, and the logic would impel him to take that next step, and instead he takes a detour. And the holding of the court is that there is a new federal rule, federal constitutional rule, that a public official may not recover damages for a defamatory falsehood relating to his official conduct unless he proves, the burden is on the official, unless he proves a false statement was made about him with actual malice, the court says. And Justice Brennan provides a brand new, unprecedented definition of actual malice, saying that for First Amendment purposes, what actual malice means is publication with knowledge that the statement was false, or, not and, or with reckless disregard for the truth. And then finally, as a constitutional rule, an impersonal attack on a government agency cannot constitutionally be considered libel of the official in charge of the agency. So what the court did in Sullivan with this result was insert into every libel case two new analytical considerations, the first of which is the status of the plaintiff. At common law, it didn't matter whether the plaintiff was a national figure, well known to everybody, was a public official, was a mayor, was a senator, was a nobody. It did not matter. That was not a factor under the common law. But under the Sullivan decision, the status of the plaintiff dictates what the plaintiff has to prove. Falsity, shouldering the burden of proving falsity, and what the court then called actual malice. The court has since recognized that that term was unfortunate because confusing. When you hear the word malice, you think that person has got an evil mind. That person wants to hurt somebody, wants to be malicious, wants to destroy somebody, injure them. That's not what actual malice means, according to the court in Sullivan. It's not one's state of mind vis-a-vis the plaintiff, wanting to hurt the plaintiff. It's one's state of mind vis-a-vis the truth. Did you know it was false, or did you publish with reckless disregard for whether the statement was true or false? And that's the second analytical consideration that was introduced by Sullivan, is what does the plaintiff have to prove in the way of blameworthy state of mind? It's actual malice. And how do you prove actual malice? There's whole separate stories about that. It's not that easy. And it's the rare case in which the defendant can be proved actually to know that the statement is false. And most of the litigation, if it gets that far, is about whether the publisher acted recklessly with regard to the truth, and so on. But the status of the plaintiff and the need to produce certain proof of knowledge of falsity or recklessness were two new elements brought into every libel case. Well, that's fine when you're talking about public officials, as Sullivan was. And that's the theory, in large part, of the Sullivan decision, is that we all have the right to criticize government and government officials. But what are we to do about the extremely powerful people in our society who don't happen to be public officials? I mean, all these celebrities, Oprah, and Tiger Woods, and all of the movie stars you can think of. Bill Clinton, he's not a public official. Al Gore, he's not a public official. There are lots of them. Mitt Romney, thankfully, is not a public official. Bill Gates, Mark Zuckerberg. These are people who run the country, and yet they're not public officials. And we'll pause momentarily for Juliet. No, the court, it was obvious that Sullivan was a public official. There was no issue about that. There was no occasion for the court to define whether someone is a public official, what it takes to be a public official. Obviously, there have been lots of cases since then in every state in which that issue has been raised. And there's not a lot of consistency around the country. In some states, the cop on the beat is a public official. In California, at the University of California, I'm sure that the chancellor is a public official. Am I a public official? I'm on the public payroll. I don't think so. Elliot? I can't hear you. No, just being on the public payroll. I mean, there are lots of people who work around Cal, who clean the restrooms, who the administrative staff, all of it. They are not public officials. The courts have, since Sullivan, paid some attention to how much power and influence a person has, and how much access they have to the media for the purpose of correcting or counteracting defamatory statements about them they have. And those are factors that play into whether you're considered a public official. But what about all these people who are powerful, influential, and are clearly not public officials? Well, 3 years after Sullivan, the court decided 2 cases. The Butts case, Wally Butts was the athletic director at the University of Georgia, who was basically accused of fixing games. And the Walker case, Walker was an Army general, I think, during the Vietnam War, who was running for office in Louisiana. He was accused of doing something. They both brought libel suits. They went to the Supreme Court. And the issue is, what about public figures who are not public officials? What do they have to prove, if anything? And the court decided in the Butts and Walker cases that public figures will be treated the same as public officials. They have the same constitutional burden of proof, falsity and actual malice, as public officials do. The gist of all this is that in addition to the common law requirements in every libel case, now if you are libeled and you're a public official or a public figure, you have to prove, the court said with convincing clarity, it's something more than the usual standard of proof, actual malice, that is knowledge of falsity or reckless disregard for the truth. As I said, the court has finally realized that that term, actual malice, is confusing to everybody, and it now says, we'll call it constitutional fault. So the plaintiff has to prove constitutional fault, defined as knowledge of falsity or reckless disregard for the truth. That or is important. It's not both. It's either knowledge of falsity or reckless disregard for the truth. Pause here for a moment of constitutional literacy. But before we do, Lindsay.
Where were the people who took out the ad in all this?
Where were they? They were most of them were in New York. They were not in Alabama.
Yeah, but did they comment on anything? Like, why didn't someone go after them as well? They were the ones who drafted these discriminatory comments.
Well, it would be hard to subject them to suit in Alabama because they aren't in Alabama. And they didn't do anything in Alabama except write their name on a New York paper that turned up in Alabama. So very likely they couldn't be sued in Alabama. But as you may have noticed, you may pick up from the decision, Sullivan did choose to sue some Alabama ministers. And Fred Shuttlesworth and Dr. Abernathy, I think, were sued as defendants. They were signatories to the ad, too, a separate category of preachers who were sued. And the reason those 2 Alabamans were sued, John, was to prevent the case from going to federal court, because there would not be diversity of citizenship between the plaintiff and all the defendants. So that the Times, when sued, would say immediately, aha, let's get this case out of Judge Jones' court and into federal court where we can make our constitutional arguments and somebody might listen to them. But artfully, Sullivan's lawyers prevented that by including in the suit these Alabama citizens, the 2 ministers, that kept it in the Alabama courts. Now to our moment of constitutional literacy. How would Sullivan have been decided? Who would have won if the case came up in, say, 1864 rather than 1964? Nick? Right. 1864 was before the 14th Amendment was adopted. There was no due process clause that was binding on the states and prohibited the states from depriving a person of life, liberty, or property without due process of law. So that Sullivan would have won his case running away. No question about it. In 1864, because First Amendment rules didn't apply to Alabama or any other state before the 14th Amendment was enacted. Another thing to kind of ponder is this a press case? Is Sullivan a freedom of the press case? Or is it a speech case? Or does it matter? And that's an issue that we'll look at later in the course. But it certainly protected the press. It was about libel, which is primarily a concern of the press, whether they can get sued for publishing something to a broad audience.